This is Paul. Yes. This court record defines based upon the court record. I got to thinking about that word defendant. You've seen me as a defendant for 7 years and 4 months. Yeah. But the people of Guam didn't see me as a defendant. It would have been against the law to continue to see somebody as the defendant when they had issued an order for dismissal and expungement. Now that happened on July 12th of 2012. Yeah. Um, Judge Ken Williams, do you see me as a defendant? Because I'm not. My wife made up a story and had me arrested. This court refuses to acknowledge that I am not a defendant. Now, am I still on trial in Jefferson County? Am I still the defendant? Are the people of Washington going to acknowledge me as not being a defendant? Now, you issued a court order in 2011, yes, without any actual jurisdiction. You had me arrested for contacting the domestic violence advocacy charity where they had a fiduciary responsibility to have the knowledge that my record would be expunged in 1 year. I tried to tell them. My record was expunged. Oh, order reissuing protection order. Did you give me notice or opportunity to be heard? Oh, from July 8th of 2011 to July 22nd of 2011. No, you didn't. I wasn't a resident of Washington State. I did not receive notice or opportunity to be heard. I was living on Guam and the jurisdiction for the arrest was Guamanian. You issued a 1 year protection order without me as the father of the 5 minors named receiving any notice or opportunity to be heard. Now, this whole concept of somebody being crazy for knowing what is most important to them. Judge, what's most important to you? Is your career most important? Is your wife most important? What are the priorities of those in the judiciary? In my life, the most important is my 5 sons. When was it that you were not going to see me as a defendant? The law would say that you had an obligation after July 12th of 2012 to not see me as a defendant. When I was found not guilty on approximately July 24th of 2012, you had an obligation to see me as not being a defendant. When you reissued the protection order in 2012 after arresting me, yes, you had an obligation to wait to see what the verdict of the jury was. The jury found me not guilty. That means they did not see me as a defendant. When the case was dismissed and I was no longer known as the defendant, you as a judiciary were obligated to see me as not being a defendant. But you didn't do that. See, you reissued this on May 31st of 2012. Yes. Without any attempt of service from May 31st to June 15th. Ouch. But then you issued a minute order 1 day before the actual court hearing. What are the requirements of the RCWs of the state of Washington? The respondent, yes, known as the father of 5 sons, must be given notice and opportunity to be heard at least 5 judicial days prior to a court hearing, and you have to have proof of service. But you don't seem to believe what the law says. That's what the actual RCW say. You refuse to acknowledge the laws of the state of Washington. You refuse to acknowledge the federal law known as the Violence Against Women's Act. You refuse to acknowledge the law known as the Washington State Foreign Protection Order Act. You refuse to acknowledge any of the laws. I tell you what the law says, and you continue to violate the law. Now, as long as you have court orders that have violated the laws, the court order is in violation of the law. I will spend every day until you remove your fraud from my life. Do you understand, Judge? I have nothing to do in this life other than get my parenting rights. As a father, I have every right to have custody, and I have the right to have all the resources that are owed to me as an American citizen. And you're obstructing my use of the judicial system because of your bullshit belief that you can violate the laws of the United States. You can't. You can't violate the law. You just can't do it. Now, you had a motion hearing, yes. Look at that. On July 6th of 2012? Yes. And attempt to service? No. Order for protection on July 6th of 2012 while I was on trial? Yes. Without any jurisdiction of law because Judge Porter had the jurisdiction of the court case. Yeah. Now, I made mention that if I've been found guilty, obviously they would have seen me as the defendant. Yes. And then they would have seen me as the convicted. Approach. As if I was convicted of a crime, but I was not convicted of a crime. And for every employee of Healthy Families of Clallam County that thinks that juries are wrong, approach. They are obligated to not have their personal beliefs. They are obligated. Every employee of Healthy Families of Clallam County is obligated to not allow their personal beliefs to trump the actual belief of the jury. The jury believed me not guilty. Do you understand? You are obligated to believe the verdict of the jury. Now, somebody thought that I got off on the case, but I was actually contacting the domestic violence advocacy charity that had fiduciary obligation to make sure that as a father of 5 sons, you enforce the law. Now, this order for protection that was issued on July 6th of 2012, yes. Based upon the court record, I was on trial, yes, and I was on probation. What happened when the jury believed that I was not guilty and they issued a verdict of not guilty? You, as a judiciary, had the obligation to believe what the jury believed. You cannot allow for your personal beliefs to overrule the belief of the jury. Now, it looks like Commissioner Kniebs, yes, didn't want to wait to find out what the jury believed. Why is it that the commissioners think that their beliefs are more important than the jury when an individual is known as the defendant in a court case and the jury believes that the defendant is not guilty? It looks like judges and commissioners think their beliefs are more important than the fucking jury.